Good morning, everyone. Welcome to the Utah Court of Appeals. I am Judge Ryan Tenney. I'm pleased to be joined today by my colleagues, Judge Christensen Forrester and Judge Mortensen. We have 4 cases set for consideration today, one of which is being argued. The case is being argued. I've seen it called different ways in the different documents floating around. We'll just go with In Re Weeks Trust. If counsel could go ahead and enter your appearances, we'll start there.
Kenneth Reich on behalf of Michelle Weeks, appellant.
Great. Welcome, Mr. Wright.
Morning, Your Honor. Robert Mansfield and Megan Garrett on behalf of Michael Weeks, who's trustee of the Augusta National Trust, and individually, along with his siblings, Jessica Weeks, Missy Weeks, and Natalie Weeks.
Great. Welcome. I think you've both been here before, but just in case, we'll set the ground rules. 15 minutes per side is allotted for argument. There's a clock on the podium. It'll work backwards. Mr. Reich, it looks like you've reserved 3 minutes for rebuttal. Is that right?
That's correct.
Okay. Are there any questions before we begin? If not, we'll hear from Mr. Reich.
And maybe before you get too far into it, I know Judge Tenney's referred to this saying, it's interesting how this case is referred to, and I think we've brought some baggage up from the district court in referring to this case as In Re Gary Weeks Trust. That's not the name of the case, right? I mean, the caption should be Weeks versus Weeks, right?
Yes, I mean, I don't know that there's an in re, I mean, it's.
That's what I mean.
Right. It's Weeks versus Weeks,
Okay,
essentially.
I just wanted to clear that up just so that we don't, but it seemed to have some reference to In Re Gary Weeks Trust below. I don't remember.
No, yeah.
So
not a-
I
Well,
just.
I'm not sure
as long
about a
as we're
Gary,
all
I'm not
clear.
sure about a Gary, but, you know,
I'm sorry,
Weeks. But
Gray Weeks, I'm sorry, Gray Weeks,
Michael Gray Weeks,
right.
Yes.
okay.
It's a thing we will pin down before the
Okay. Thank you. Kenneth Reich on behalf of Michelle Weeks is the appellant. May it please the court and counsel. So this case, it's a family case, and just for ease of reference, I'm going to refer to the first names of the individuals because everyone's Weeks just about, except for an ex-wife. So in this case, there's a bit of complex things going on, but we're requesting reversal of, well, vacation of an order or a judgment for eviction of my client from the house. To kind of walk down the different claims, I think the briefs go through it very, very well, but if at any time, honestly, if you have questions, I'd much prefer to answer questions than to go through essentially what's in the briefs.
I'll take you up on that invitation. Let's start
Okay.
with the issue of who should be considered the wife for purposes of the first trust. Fair?
Okay?
If he had only meant to refer to or to designate his current wife as the beneficiary for purposes of that clause, why include Sue's name at all? What was the purpose of putting her name in there if your reading is right?
She was his current wife. I mean, other than that, I can't think of another reason why you would,
But then why not just say that? Why not just say my current wife? It seems to me that putting her specific name at least is arguably an indication that he's referring to her as opposed to somebody in the role of wife. Why is that wrong?
Well, I don't think it makes a difference in terms of why he would do that. I mean, I don't think it makes a difference. But I mean, what happened though was that she was stricken as essentially her name is stricken from the document by her divorce. So whether he intended
does
to
does the divorce say that? Does it say that she's stricken from the trust?
No, but that's the legal effect. I mean, is that I can't think of another reason why a legal basis to keep her in that position. And in fact, it's admitted
I
by
think they're going to tell us that the legal basis was that the trust was intended to have her specifically as the beneficiary. So,
well, but the intent of there's not an ambiguity. It says settlor's wife, and she is essentially defined. I mean, identified at that moment as settlor's wife. But that doesn't mean that she will always be settlor's wife. I mean, just as the kids are identified, there are three children identified, but there were 3 afterborn children from the time of the trust.
I mean, one of the things I've thought about as I've thought about that part of that issue is You can look at it through the canons of construction, and one of the canons of construction that courts use with some frequency is the general and specific canon, and it says that if you've got a general term and then you've got a specific term, you go with the specific. And I think one way to read this trust here is you've got a general term, quote, settler's wife, and you've got a specific term, quote, M. Sue Weeks. So if we follow that canon, why wouldn't the answer be the specific controls, meaning Sue Weeks is the beneficiary, not the wife part?
And the answer to that is because she's identified only by definition, essentially. So it's settlor's wife, comma, M. Sue Weeks, comma, and then it goes on. And so she's not identified specific. It's not settlor, M. Sue Weeks, comma, and whoever else. She's identified only as by definition, and she's not identified elsewhere in the document, and she's not a signatory to it. So there's no reason to say that under that canon that it's a specific term. Actually, the specific term is that there's a definition, settlor's wife, and that she meets that definition at that time.
That's helpful, thank you.
Fair?
Fair.
Other questions?
I have more. Keep
Well,
going.
well, I'm happy to talk about questions other than, because I think the briefs are very well, they lay out the argument. So I'm happy to answer questions if you have questions. Otherwise, I will move on.
Go for it.
Please.
Can you just generally address I don't know what the adjective is, irrevocability of the trust?
Sure. So it is by its own terms irrevocable, correct?
Yep.
And by statute, an irrevocable trust can be modified or terminated by agreement, by consent of the settlor and all beneficiaries. Fair?
Fair.
And the divorce decree is that consent. It was the agreement between the settlor, Kenneth, and his then wife, M. Sue Weeks.
And
Correct.
we shouldn't be troubled that it doesn't expressly say that?
Say the word consent?
Or how much reference is there to the trust?
There's no reference to the trust.
That's what I thought. So should that be concerning to us, that you're claiming, or that we're supposed to see that significant of an action here when it's not even specifically identified?
Well, I don't think so, because the trustee didn't need to be a part of that, of the divorce decree for that to be a consent under the statute. The trustee doesn't have to be a party to it at all. But what the divorce decree did was identify the parties themselves, stipulated, here are our assets, and here's how we're going to divide them. And it identified what they knew were trust assets. Whether the court knew it or not, I think is irrelevant, because the court wasn't being asked to determine that this was a consent. The court was just simply asked to divide the marital assets of the parties. And so, and it did so, by the parties' consent. They said, we own these assets. And when I say we, settlor, all the beneficiaries own these assets, and here we are stipulating that they can be divided by this court as marital assets in this divorce in this way. And then this court, the trial court in this case, had the trustee before it and was asked to ratify essentially that divorce decree as a consent of trust as settlor of settlor and the beneficiaries.
You would agree, I assume, that there would need to be a valid consent from the children, right?
Right, which was through their parents.
Through their
But go ahead.
parents. And in response to that, in the red brief, the other side argues that Sue and Kenneth couldn't have consented for the children because they have a conflict of interest. I'm wondering if you could address that.
Well, so if you go back to the Dahl case, the Dahl case lays out the interests of a divorce court to divide marital assets. And there was nothing raised in the trial court about, well, they had a conflict and an exploration of, well, what might that conflict be? And frankly, I will say that there is no conflict. This was a family that was dividing. These were marital assets, or at least the parties considered them marital assets, and to the extent that there was,
But if the children have interest in that property by virtue of being beneficiaries of the trust, aren't the children in something of an adverse position with respect to their parents in terms of that aspect?
well, and I think that would happen in any divorce.
But then doesn't that negate the ability of the parents to consent to the modification of the trust?
I don't think so, because, and here's why, is because the trial court in the divorce case has the best interests of the children in mind. I mean, that is something that's considered by.
But when the trial court is making an order with respect to dividing the marital property, it's not, in that portion of the divorce ruling, it's not thinking about the best interests of the children, it's just trying to divide the marital property vis-a-vis the spouses, right?
Well, yes and no. It's between the spouses.
What's the no part?
Well, I mean, the spouses, the division of marital assets is not just simply to divide it between spouses, but there's also a consideration of being able to care for the children by the parents.
But that's handled with respect to child support, right?
Well, child support and division of marital assets can also be a component of child support. I guess the point, though, is that there was never an issue raised before any court, frankly, about whether there was a conflict of interest and whether that should have been litigated or considered. And so for us to kind of
You're saying the conflict issue was not raised at all below?
Correct, was not to my knowledge.
Let's just assume it was. Let's just assume there's no preservation problem there. One of the things you said in response to that in the reply brief was that there needs to be evidence of the conflict of interest. Why wouldn't the divorce decree itself be the evidence of the conflict? Because if the divorce decree is purporting to give Sue $320,000 and it's purporting to give him the two properties, at that point it's giving each of them an interest in what they were receiving with respect to the decree. That's arguably adverse to the children's interest in having access to the same corpus. Why isn't that the evidence?
Well, and why isn't that the evidence of a conflict?
Yeah.
And I think the answer is part of the answer is that if you go back to the terms of the trust itself, the trustee, the settlor was entitled to essentially through the trustee to all of the assets anyway. So, the kids would I mean, it's essentially a trust that could have been used up and there would be nothing left in the trust at the end of the day. But what the husband and wife were doing was dividing these assets now. And so to say that there was a conflict, I'm not seeing what the conflict is.
Well, I think what the children are seeing with respect to the alleged conflict is the children are saying once those two properties are put into the trust for our benefit, then if the parents are purporting to divide the properties between the two of them, that's taking property away that was supposed to benefit the children. I think that's what they're saying that is what they're saying the conflict is. Why is that not a conflict?
Well, it's not a conflict because the settlor and settlor's wife were entitled to use those assets for their entire lifetimes before the kids would ever see the assets anyway. So I'm not sure that whether there's the existence of the conflict, and I think the case that I cited is that you have to identify that the conflict made a difference to the decision that was made by the parents in the situation. Meaning, would they have made a different decision, or
Is
would
that right,
somebody
though?
else
Because
standing in their shoes made a different decision?
Is that right, though? Because the Utah Trust Code says that you have to have consent of all the beneficiaries, and if they're not legally authorized to give the consent, why isn't that the answer at the outset of that inquiry?
Well, I think that the existence of a conflict versus my time is up, but
Ignore the clock. As long as we're
Okay.
asking you questions, ignore the clock.
okay. So the existence of the conflict doesn't negate their ability to act on behalf of of their children.
Wouldn't you agree that as a legal principle, if you've got a conflict of interest, then you don't have the authority to give valid consent for somebody for whom you have a conflict?
No, I don't think that's always the case, because I think there are conflicts of interest can exist, and still, the authority can exist at the same time.
I mean,
And
if a judge has a conflict of interest with respect to a party, can the judge issue rulings with respect to that party?
I'm sorry.
Let's just suppose that I have a conflict of interest. Let's suppose that I'm financially tied to a party that's before me. I couldn't issue rulings, even if the rulings are fair, could I?
With the consent of the parties, you could.
I suppose, yeah. So that's your argument then, is that the children have consented to this?
The trust agreement itself says that the parents can act on behalf of the children. I mean, it's part of the terms of the trust, that they can act on behalf of the children. And then in the divorce itself, it's by implication that they are acting on behalf of their children. I mean, the children are there through their parents, and all the custody issues, everything that's going on in the case, they are present before the court as well. And to the extent that there was, any concern by the court that the children were that there was a conflict. Well, the court wasn't aware of, the divorce court was not aware of the trust, but that doesn't mean that the conflict made any difference to the decision of the parties.
Can I take you to a different issue, unless one of the judges wants to stay there?
I'll just take a turn and give you a break for half a second.
Yeah.
Does it matter, in the divorce decree, I understand there's actually a difference between the language employed as to the immigration law and the language employed in the decree as to the home in Draper. The court awards the interest. It doesn't purport to award the house. It says it awards the interest. Does that, using the term interest, does that inform what the court thinks it's doing? In other words, now you just told me the court doesn't know about the trust, but does that have any specific legal effect to award an interest as opposed to saying I'm awarding all the bundles to you? Because it seems to me that if the court is awarding the interest, the court isn't saying what the interest is, it's just saying whatever the interest is in the property, that's what I'm awarding to you. And sometimes an interest can be less than the whole. Do you see what I'm getting at?
I can see that, and I think in this case, in certain cases that could make a difference, but in this case, I don't think it does, because at the outset of that distribution, the parties declared that this was their property, and so there's not.
So it doesn't matter if the parties are wrong?
Well, I don't think they were wrong. I think that they were.
You know, if my dad lets me drive his car and then I get divorced, but I've been driving his car the whole time, and in my decree I say the car is ours and I'm gonna have the car awarded to me, does that magically make it my car even though it's owned and titled to my dad? I feel like I'm Greg Orm.
Yes.
That sounded like a Greg Orm question, but.
In that case, I don't. That I think that's a different analogy than in this case, because who we're talking about though is the settlor and the beneficiaries of the trust that held legal title to the property, and so they really did own it, or they could modify how it was owned or how it was distributed, and so in this case they declare by consent that this property, even though they didn't tell the court, is held in the name of a trust, is being distributed to them individually, and in this way. And so, because I think it's just simply I don't think there's any. I think it would be a mistake to read into it something that's not there by saying all interest of the parties in these properties. I think is just simply a legal shorthand way of saying, I'm not identifying it as you've got a warranty deed on the property or whatever. It's just, it's yours. And we declare that it's ours, and now we're dividing it this way.
All right. Let me ask you a question about a different part of the case. There's been much briefing about whether there was evidence before the court establishing that there was a second trust. This is the parole evidence discussion in the briefing and so forth. One of the things that struck me as I was thinking about that issue is this. Suppose we conclude, I'm not saying we are, I'm talking about the case, but
Sure.
Suppose we conclude that the first trust was not modified or dissolved.
Okay.
Suppose we conclude that the two properties remained in the first trust. Is
Okay.
there still reason for us to decide whether there was the creation of a second trust? Because at that point, it wouldn't have any property. So would we still have to decide that set of issues?
No, because the trust, the trust would own nothing. I mean, there would be
Right.
no assets in the trust. In the trust number one, then a number of the trust issues that we're talking about go away because the properties are owned elsewhere.
Right, and so there'd be no reason for that second trust to exist if it didn't own anything, right?
Correct.
Okay. I mean, I suppose we would still need to confront the equitable estoppel issues and some of the other stuff. But as to the issues, the parole evidence issues regarding the alleged creation of the second trust, I think that's right, that those would go away, right?
Right, because the properties would then be owned by Kenneth individually, and they
Well,
would.
no, they'd be owned by the first trust in theory. But if we conclude that the first trust kept the two properties all along,
Oh, okay, sorry.
that's what I'm asking. Suppose we conclude that the two properties never left the first trust.
Okay.
Do we have to decide whether there's a second trust?
Well, I mean, if the conclusion is that there's not a second trust, and that the first
Well, no,
trust.
that's flipping the order. My order is really particular. If we conclude that the two properties never left the first trust,
Okay.
at that point, there's nothing for the second trust to own, the alleged second trust to own, right?
Well,
So at that point, do we need to decide whether it exists?
I think the second trust exists because it owns at least one of the properties.
Yeah, let's just assume again, I haven't spoken to my colleagues about the case.
You're Greg Orm too.
Right, let's just say, I'm just thinking through the different iterations of how the decision would go. If we concluded that both of the properties never left the first trust, do we need to decide whether the second trust was created?
Okay, so let me make sure I'm understanding you correctly. So you're saying, let's assume that both properties were put into the first trust.
Right.
And then have never left.
Yeah, the divorce decree did not act as a modification with,
Divorce decree didn't do anything.
they stayed in the first
And-
trust. If we think that, do we have to decide these parole evidence issues? Do we have to decide at all whether the second trust was created?
Well, I think that the existence of the second trust is tied to whether or not the lot actually went into the first trust. And so it's like, it's
Suppose
hard for me to like
Right. but
separate it out.
Yeah, you work with me on this one. Suppose we think that the two properties.
I know, I'm working.
I know. I've been there.
Working here.
I've been on that side of the podium.
Yeah.
Suppose we think that the two properties went into the first trust, stayed in the first trust. The divorce decree didn't change that. Is there any reason at all for us to decide whether the second trust was actually created?
Well, then I guess the answer is no, because then the second trust, actually, the property was not actually transferred into the second trust.
Right.
So it's essentially a determination that the second trust
There's no purpose for it.
didn't
right?
didn't ever happen.
Okay, that's what I wanted to make sure I had right in my brain.
So, yes.
I mean, and I fully take your point.
Sure.
I don't want you to sit down and think, oh, I didn't
Yeah.
make the point. You disagree on the first part of my question. Totally get
Yes.
it, and it's a thing we'll think about, obviously.
Okay.
Those are my questions. Am I missing anything? Okay, thank
Okay.
you. You'll get your full rebuttal time. We
Great.
kept.
Thank you.
Good morning, may it please the court and counsel. Again, my name is Robert Mansfield. With me at council table is Megan Garrett. Also with me is Michael Weeks, Natalie Weeks, and Missy Weeks. Appreciate the opportunity this morning here. If I may, let me launch into this issue of consent. Obviously, Your Honor had some
Was it
issues.
preserved?
That's the first point. It was not preserved, and that's one of the reasons why this issue of whether there was or was not a conflict was never developed in the trial court. There are no facts.
If it's not preserved, how do you rely on it here? I mean, we have recent case law from our court, I think it's the Kelly decision, that says that in civil cases, plain error doesn't apply. So if it's not preserved, can we rule on that basis?
Well, I don't think you can rule on it if it wasn't preserved, because you need a factual basis. Was there a conflict? Your Honor had a lot of questions about the fact that the kids have this remainder interest in the property after the lifetime of Ken and Sue Weeks. Does that automatically create a conflict of interest between Ken and Sue and their division
of the property, and I think it would. I think the evidence, if it were raised in the trial court, and if that were developed, that would be shown what the conflict of interest would be. One thing it has to remember too is this, is under the trust, there is no requirement that either Ken or Sue or anyone get any benefit whatsoever during their lifetimes. If you look at the trust, at paragraph 4.10, or section 4.10, it talks about trustee shall pay to or for the benefit of settler or settler's wife or settler's children as much of the net income and principal of the trust as trustee deems necessary for their health support and maintenance. Then it goes on. Trustee shall have unlimited discretion in deciding what distributions, if any, shall be made to settler, settler's wife, and settler's children, or any of them, hereunder or during settler's lifetime. They didn't have a right to live in the home. They didn't have a right to use any of the assets.
Okay, before we go too far down that road, I just want to make sure I've got the answer right. If you didn't argue below that there was a conflict of interest with respect to whether the children were consenting, what's the basis for us ruling on that argument now? How do we do that?
Certainly. The problem is petitioner Michelle Weeks did not assert below that the divorce decree operated as a consent.
So you're saying you didn't need to preserve it because she didn't preserve the thing?
No,
that's in
she didn't
response
raise
to
that.
it.
What they said is they didn't need consent. Not that the divorce decree operated as consent. Because of that, we were never offered the opportunity to develop the factual record that would show that how that could not operate as consent, because there is an inherent conflict of interest. And if there is a conflict of interest, in which I think there would be, then neither Sue nor Ken could operate in the capacity of parents and offer the consent for the children. I think there would be that conflict of interest. Now, Mr. Reich also refers to the Dahl case and how the property of a trust is marital assets. It has to be remembered, under the Dahl case, that was a revocable trust, not an irrevocable trust. Now, in Dahl, the title of the trust was irrevocable trust, but the trust document itself in Dahl specifically reserved to settler, to Dr. Dahl, the right to amend the trust. And the Dahl court held that the right to amend includes the right to revoke, so therefore it's a revocable trust. This trust is very clear that it's irrevocable. It has all the indicia. Section 3 says this trust shall be irrevocable. Settler shall not have any right to amend or otherwise alter or revoke this trust in any manner whatsoever, or to alter or divest the interest of or change the beneficiaries, or vest the power to terminate or amend this trust in any other reason. Also then, if you look at 410, as I mentioned, there is no contingent interest that the settler had. That's also an indicia of a revocable trust. Do they have some sort of contingent, mandatory contingent right, which they don't have? This is solely at the discretion of the trustee as to what rights or benefits settler or settler's wife, Sue Weeks, would have during the pendency.
Can I take you to the wife issue that
Yes.
we led with? Why isn't that sequence within the trust at least ambiguous? I mean, where it says settler's wife, comma, M. Sue Weeks, there's a plausible reading, as I just exploded with opposing counsel, there's a plausible reading that it's referring to Sue specifically, but there's also, I think, a plausible reading that it's intended to refer to whoever his wife is. And if those are both plausible readings, why is this not an ambiguous phrase?
First of all, there's never an assertion that was ambiguous in the trial court. So the trial judge did not entertain that question of whether there was or was not an ambiguity. And Your Honor pointed to
Let's suppose we don't have that problem. Let's suppose
Okay.
I'm asking you, we'll think about that. Is it ambiguous?
I don't believe it is, because
Why?
it specifically references Sue Weeks by name. It says settler's wife, comma, M. Sue Weeks, comma. Now, as Your Honor pointed out, and typically use normal rules of contract interpretation with the trust, just like you do any contract. If you do that, if you ignore Sue Weeks as that is who was specifically intended, not just someone who occupies the position of the wife of settler, you would have to read out of that document M. Sue Weeks.
Right, but this is what struck me about this, and now I'm pushing back in your direction. When I look at that paragraph, it says during the lifetime of settler or settler's wife, comma, M. Sue Weeks, but then it continues. trustee shall pay to or for the benefit of settler, comma, settler's wife, comma, or settler's children. It doesn't repeat her name. And so,
does not.
so there's some arguable suggestion there that what is really after is who his wife is. Full stop.
There is some suggestion, I see your point there, but I still think you would have to read out the prior specific notation of M. Sue Weeks as his wife. And I think it would require reading under.
I think what he's going to tell us in rebuttal though is, well, no. In my brain, if you tweak the scenario a little bit, it starts looking a little funky, because suppose they'd gotten divorced the very next day and he gets married to somebody else and he lives with her as man and wife for 30 years. There's at least some suggestion from sort of what's the purpose of the trust concept, that what he was really after was he was trying to take care of who he was married to as opposed to this particular person. Right? I mean, that's what they're telling us.
No, I understand that argument. I mean, and you look at the timeline. The trust was formed in November of 1993. The first property was not even transferred into the trust until 1995, and that was the Emigration Property Trust. And then about 2.5 years later, at the beginning of 1998, the Draper home was transferred in to the trust. Ken and Sue then got married divorced about 2 years later on October 8th of 1999. The next day, he marries, on October 9th, 1999, he marries Michelle. No effort was made to properly amend that and replace it with, here's who I intend to be. I now intend that Michelle Weeks be the person who has this right to occupy the property. Now, he attempts to do that, give her the 5-year tenancy under the 2006 instructions agreement. Again, I think that's and as we've briefed, that's an improper modification. Ken did not have the right to modify or amend the trust agreement. Also, it's interesting, the 2006 instructions document makes clear that Ken certainly considered this trust to still be ongoing, that the divorce decree did not have the purpose of eliminating the trust agreement. As counsel argued, the divorce decree had the effect of eliminating or nullifying the trust. Ken certainly considered the trust still to be ongoing in 2006 when he signs a document saying the trust has two main assets, the Emigration property and the Draper home. And he specifically refers to the trust.
Unless we accept their argument that what he's actually referring to at that point is a second trust.
Now, this is interesting. The assertion below of a second trust was that it had, well, in the petition, they assert that 2006 instructions document was the actual trust, and that's a paragraph 42, record 7 of the petition. There's a direct assertion and an attachment of that document as an exhibit to the petition saying, this is the second trust. Well, even if that is the second trust, and this goes to your final question, Your Honor, even if there's 50 trusts that specifically say, I hereby declare that these properties are part of the trust, the problem is you have no deeds transferring the property out of Augusta Trust number 1 into any new trust. The last deeds, the only deeds affecting these properties are the one in 1995 for the Emigration property. Again, this didn't come from Ken and Sue as married parties. This came from an outside source, directly into the trust. And then 2.5 years later, in 1998, the Draper home, again from an outside source, directly to Ginger Monson, both of them to Ginger Monson as trustee.
Although I think what they're going to tell us in response to that is they didn't need the deeds because the divorce decree had effectively done that as a matter of law, right?
Well, I still think even if the divorce decree ordered that it be done, you still have to have a transfer into a new entity.
I believe, unless I misread it, their brief's telling us that the 1995 deed, since it doesn't have the numerical designation of number 1, was an anticipatory deed of a trust to be created 10 years in the future, or something like that.
I don't take that as the argument. Their argument, I think they ignore the timeline and just argue that is into an existing deed, or excuse me, an existing trust, the second trust. Now, the evidence, their assertion of the evidence that there were two trusts Augusta Trust, Augusta National Trust number 1 is misspelled AGUSTA. The 2006 agreement, if you look at the 2006 instructions, at the top says grantor of Augusta, spelled properly, National Trust, and says the trust has 2 main assets. These are residence house and property located at Last Camp Circle, Emigration Oaks. The deed is very clear from the residence house. It goes to Ginger Monson, trustee of Augusta, misspelled, Augusta National Trust number 1. The deed for the emigration goes to Ginger Monson. Monson's misspelled. The evidence was Ken Weeks was a notoriously poor speller. It went to Ginger Monson, trustee of Augusta National Trust, Augusta spelled properly. The unrebutted testimony, and is found by the trial court from Ginger Monson, and that's Ken Weeks' sister is a trustee, is that I was only ever trustee of one trust. Ken never asked me to serve as trustee of a second trust. There's only one trust in which I was ever trustee, and there's only one trust document that's ever been submitted that she signed, which is the Augusta Trust, Augusta National Trust number 1.
But I think that's their point, though, is to the extent that this was decided on summary judgment, the district court's required to view the inferences the opposite direction, isn't it?
Reasonable inferences.
Reasonable inferences.
And there's no reasonable inferences here. Now, also, if you look at Michelle's declaration, much of that is based on hearsay, inadmissible, statements based on hearsay. What Ken had told her, what Christian, her son Christian, had said to her. And the court found, didn't make a specific ruling, but that was our assertion. Our objections to the evidence was based on hearsay, and the judge found that those statements were inadmissible. Also, the statement was that even though the petition, and she should be bound by a statement, an admission or an assertion in a pleading, and we've cited the authority for that, specifically states that the 2006 instructions was the second trust. Now, later she tried to say, I saw a different document, trying to create this question of fact. I saw a different document that had the same terms as the 2006 instructions. Well, that obviously had to have occurred post his marrying Michelle, because if Ken in some other document is giving Michelle an interest, it's going to be post their marriage.
Okay, putting aside the question of whether the 2006 agreement evidence is the creation of a second trust, they're also using it, as I understand it, as the basis for their equitable estoppel argument. One of the things, there's a lot of moving parts to the equitable estoppel argument. One of the things that struck me, the reply brief on page 19 cites testimony that, quote, Michelle testified that she relied on the 2006 agreement in paying debts on the home and lot. Is that true that she testified to that effect? That she relied on the 2006 agreement to pay debts on the home and lot?
During the trial, she did state that in opposition to the motion for summary judgment that was before the court. For that was not, no such assertion was made. There was the bald assertion that I relied on the 2006 document, but no surrounding facts to support what that reliance is.
I think from that, I think I know your answer to the following question, but let me ask it just to make sure it's straight in my mind. We're asked to review the equitable estoppel determination from the district court. In light of that testimony, why hasn't she at least gotten through the reasonable reliance element based on that testimony?
Well, part of the reasonable reliance argument is this, and also what they're arguing on appeal, how they're applying the equitable estoppel argument changes on appeal from how they did it below. But how's that not reasonable reliance is, one, you have the Utah Trust Code, which requires that any irrevocable trust only be amended in a certain fashion. You have the trust agreement itself, which states that Ken does not have the power to amend or modify the trust.
But even putting aside modification and amendment, isn't there a universe in which the trust could say to her, hey, we the trust are not going to kick you out for 5 years? And if so, why can't that be the basis for an equitable estoppel determination?
Well, I think it would have to be a statement of the trustee First, and there is no statement of the trustee. The 2006 instruction documents are statements of Ken.
But they're notarized by Ginger.
Well, they're signed by Ginger.
They're signed by
Her-
Ginger.
Yeah, and her
So-
signature is notarized. She's acknowledging receipt
She's
of that. but
acknowledging
those-
it. So for purposes of equitable estoppel, if I'm Michelle, why can't I say, look, I've got a written document from Ken, notarized by the trustee, saying they're not gonna kick me out for 5 years. Therefore, I'm gonna keep paying the rent. Therefore, you can't kick me out for 5 years. I understand that to be the equitable estoppel pitch. Why is that wrong?
Well, the equitable estoppel pitch is not just for the,
It also goes to the property.
It goes to the
Yeah,
immigration
put-
property,
Put that
as
aside, at
well.
least with respect to the 5-year tenancy. Why is that wrong with respect to that part of that claim?
because again, I think as a matter of law, it would be unreasonable for her to rely on that statement because they don't have the authority to modify the trust. Now, in the reply brief.
Do you have to modify the trust to say we're not gonna kick you out for
Okay,
5 years?
But they came, in the reply brief, they came up with a new argument. And that's the first time they've ever raised that, saying that under the trust agreement, Ginger had the right to transfer, sell, or do anything with the property or to affect it. That was never raised below. The first time that came up was in their reply brief on page 18 of the brief, where they say the trustee could transfer any property at any time held by trustee for cash or other consideration and upon such terms and conditions and for such price as trustee may determine. Well, the 2006 agreement occurred September of 2006. According to the testimony, Michelle did not start making any of these mortgage payments until 2009, so several years after that. And now that also goes to the unjust enrichment theory that was made that I think the petitioner has failed to marshal the evidence for that. Again, neither Ken nor whoever his wife may be, whether it has to be Sue or whether it could be Michelle, had a absolute right to live in the home during the pendency of their lifetimes. That was under the unlimited discretion of the trustee. The evidence at the time of trial was clear too. The trust had no assets other than the two properties. They had no cash. In exchange, as the trial court found, in citing the case law as well, is that in consideration for just living there during their lifetimes, allow that, they got a benefit. So there was no undue benefit to the trust as a result of her paying the mortgage payments or the utilities.
Go.
Can I ask what might seem a very basic question? In looking at the language of the trust number 1, provision or 4.10 identifies M. Sue Weeks as Settler's wife, right?
Yes.
And then at the end of the trust, in section 11, the then living children are identified by name as well. So, but that provision contains language that, these are my children, and with reference to the child or children of settler shall include any children which are born to settler or adopted by settler subsequent to the date of execution of this trust agreement. Would there have to be that same language in section 4.10? Would it have to say to not have M. Sue Weeks as the defined settler's wife? Would there have to be language like is found at the end of the section, or anybody else that I may marry during my lifetime?
Yes, I think it would, and this shows that, and again, under ordinary rules of contract construction, this shows that Ken clearly knew how to provide for subsequent children, whoever they may be. And he did, as you point out, he did specifically list the 3 children who were then living, and then had a specific provision providing for additional children, whether they be born or adopted, subsequent to the date of the trust. Similar provision, I think, would have to also be there for Sue Weeks. To eliminate Sue Weeks, it would have to have a provision, something of, the fact that he mentioned her name, then, I think I would then require a provision that says, or whoever my current wife may be, or my, current spouse, or, something to that effect. But the fact that he used Sue Weeks by definition, and he knows how to make provision for changes in circumstances, that would also have to be done with respect to adding Michelle Weeks in place of, or in lieu of Sue Weeks.
We have kept you well over, but it's been in response to questions. Are there any further questions before we let him off deck? Okay.
Thank you,
for your-
appreciate your time very much.
Thank you. Mr. Reich, get your full rebuttal.
Thank you, Your Honor. So the case at the trial court.
Did I get it right where you were arguing about the deed on the immigration lot, that you were saying that that was a deed in anticipation of a later created trust? Were you arguing that, or did I misread that?
Of a
You
later,
understand?
I'm
Well,
not,
the deeds from the deed
from 1995.
obviously
lot.
precedes, I think, when you are asserting that the second trust was created. No?
No, so I mean, the second trust, and actually, our argument is there are two separate trusts that, and in fact, the number one trust anticipates that there is a second trust. I mean, and the point is, and I will get to that in just a half a second, is that this is a motion for summary judgment. I mean, we're, you know, Michelle didn't get the benefit of the evidence in her favor. And so when you're looking at the two different trusts, so the argument is that two trusts existed. I mean, we have the written document for Augusta National Trust number 1, dated whatever, 93. There was a second trust that Michelle testified that she had read that was the Augusta National Trust, not number 1. And that trust received the lot. Does that answer your question?
Mostly, yeah. Sure.
And so that both trusts existed as of 1995.
Okay.
But the trust number 1 didn't have anything in it until 1998, when the home would have been transferred into it.
Yeah.
So a couple of, I mean, back to the point was that this is a motion for summary judgment. I mean, that's how all this, you know, rolled out, is that there are issues of fact that precluded summary judgment, and they're in the brief, and they are in there. And let me address specifically the 2006 agreement. So the trustee, I mean, council would like this to be, you know, a document that just simply, you know, the trustee signed it as simply, oh, I got your instructions and nothing else. But this is actually the trustee executing this document. This is a binding document on the trust through its trustee. There's been no challenge to the 2006 agreement.
But if the trustee doesn't have authority to do that, I mean, this goes more pointedly to equitable estoppel, but if the trustee doesn't have authority to do that, then how can Michelle reasonably rely on it?
Well, I mean, why can't she rely on it? The trust statute says that, I mean, that a third party can rely on the acts of a trustee without having to go down and drill down to the actual trust documents. But that aside, she's entitled to rely on it because actually, if you drill down to actually look at the trust document, it says that the trustee can do that. I mean, the trustee has very, very broad authority to do that.
But isn't the trustee constrained in some sense that the trustee has to act for the benefit of the beneficiaries?
Yes.
And so if there's two pieces of property within the trust, there's the Draper home and there's the immigration lot. And if the second trust purports to just simply give away one of those two pieces of property, in what universe would that be for the benefit of the children who are the beneficiaries of the first trust?
So and now we're kind of combining things. It's like we have two trusts. So assuming that the divorce decree.
Yeah, well,
removed-
let's just assume, let's put that aside briefly.
Okay.
You got two trusts, right? You've got trust number 1 in which there's two properties.
Right.
And as I understand your argument is that the second trust, well, right, your argument is the second trust ends up getting those two properties, right? But part of that is you're saying that the 2006 agreement gives Michelle the second property just outright.
Yes.
Do I have that right? How would that be for the benefit of the children who are the beneficiaries of the first trust?
Well, to the extent that they weren't beneficiaries of the second trust. I mean, it's
Right,
the same-
but if your hook for that is that the trustee of the first trust has authority to do this, but the trustee in the first trust is supposed to be acting for the benefit of the beneficiaries. How can she just give away property that was intended for their benefit to somebody else? How can she do that?
Well, that's up to the trustee. And so if there's an issue with the trustee doing something that is like outside of the authority of the trustee, that's an issue that the beneficiaries need to bring up with the trustee as a claim against the trustee. There's not that claim. What we have is Michelle relying on what the trustee did and what the trustee said, which is you get to live in the house for 5 years after Ken dies, and you get the lot.
Right.
And so, unless there's a challenge to that the trustee acted beyond its authority, which they haven't challenged it. I mean, meaning the beneficiaries haven't challenged that act, and that's a claim that they can bring against Ginger Monson for acting beyond her authority.
Makes sense. We've kept you over time. If there are any further questions? If not, thank you very much for your
Thank you.
argument. I appreciate the briefing and arguments on this case. They were helpful on all fronts. We will do our best to issue a written decision as soon as we can. And with that, we'll be adjourned.